Hello, everyone, and welcome to Uncivil Law. For today's case, we have a story dealing with vistic overlooks of national parks. Some people would like to fly in planes or helicopters or otherwise be able to surveil national parks from the air. Sounds very pleasant. And the federal government thought, that sounds like a good plan, but maybe there should be some rules so that nature won't be disturbed and people won't be disturbed so everyone can enjoy the park. Unfortunately, there's been a 20-year match a 20-year throwing poo fight between the FAA and the National Park Service, who refuse to get along because they all want all the jurisdiction ever. Not like this has never happened before in the history of the federal government. This entire reason Department of Homeland Security was invented because federal departments can't get along. But at least for a moment, today's story is about National Park Service and the FAA having a fighting match over who is the best federal agency, and nothing getting done as a result. Let's just start with this. The Air Tour Management Act of 2000 requires vendors who wish to conduct commercial air tours over certain national parks and tribal lands to obtain a special permit from the FAA, because we want people to be able to enjoy the lands, enjoy the parks. We don't want to scare the animals, but we want people to enjoy their overlays, so we will create a program so everyone will be happy, or in the alternative, everyone will be equally irritated. But either way, that'll be a win. So the Act provides that the FAA, in cooperation with the National Park Service, which never happened, shall establish an air tour management plan whenever a person applies for authority to conduct these air tour operations. Management plans may prohibit these air tours entirely or place certain conditions on them, such as maximum or minimum altitudes, time of day restrictions, maximum number of flights per unit of time, and mitigation of noise, visual, or other impacts. So, federal government wrote a law that says, people want to look at national parks. Maybe we should have some special rules for this because there's a lot of interesting considerations. People flying at low altitudes, they're not flying in special craft. So maybe we have to have some concerns. So, you can ban it entirely. What you don't have to do that. You can set, zones of flying. You can set hours. You can set rules. It should be fine. All you have to do is FAA has to work with the National Park Service. That'll be a problem. Congress directed these agencies to act with dispatch. That didn't happen. The Act provides that the FAA shall make every effort to act on an application and issue a decision not less than 24 months after it was received or amended. The Act also allowed the FAA to grant interim operating authority to any existing operators so they wouldn't be put out of business. So Congress, thinking ahead, so nice Congress for thinking ahead, thought, maybe some people are already in business and we don't want to disrupt them. So we can create these interim authorities to deal with that. So Congress tried. The agency's efforts to comply with the Act got off to a promising start. It wasn't to last. In 2000, they established the National Park Overflights Advisory Group. And by 2002, they had published a rule defining commercial air tour operations and launching a permit application system. It all sounds so promising. But trouble began to brew when the agency started to respond to the applications. So once applications started coming in, they had a fight. Each agency prioritized different goals and sought to retain as much control over the process as they could. The children are not able to play nice with others. The FAA emphasized air traffic safety, which, that's fine. The National Park Service protecting park resources and visitor experience, which is also fine. These are both laudable goals. The FAA should definitely be concerned with air traffic safety, and the National Park Service should definitely be concerned with protecting resources and visitor experience. These both sound like goals, but they don't sound like they're majorly overlapping goals, so surely the FAA and National Park Service can cooperate because their goals, both while important, are not really in conflict. But no, the children can't play nice with each other. As a result, the agencies bickered over everything, from responsibility for making certain determinations to the proper metric for measuring baseline noise levels. Okay. For example, the Park Service sought sole jurisdiction over environmental impact determinations on park resources, which sounds like that should be within the domain of the National Park Service. The environmental considerations for park resources. Doesn't sound a lot like dealing with air safety, but the FAA refused to abdicate its role in that process or defer to the park's superintendent's professional judgment. So the FAA suddenly thinks they're environmental experts of national parks. 12 years later, the agency still hadn't come up with a single management plan. In an effort to speed things up, Congress amended the Act, so Congress has taken note. That's attempt has been thwarted. The Congress is like, okay, look, guys. In 2000, we wrote a bill that said, look, just play nice with each other and write some rules and create some air things. And for 12 years, you guys have been bickering around and you have been unable to play nice with each other. So, Congress, we're going to try it again, and we're going to try to fix this so that you will play nice with each other. Okay. So, in an effort to speed things up, Congress amended the act to exempt parks with 50 or fewer air tours per year, fine, and permit the agencies to enter into voluntary agreements in lieu of management plans. We're trying so much. So these voluntary agreements are much more flexible and easier to implement because they're just mutual agreements between everyone. Everyone can hold hands and sing Kumbaya. The agencies need not jump through as many procedural hoops to create them, and they're not subject to full notice and comment. So, if we were going to do like formal rulemaking, if we want to have a formal management plan, a formal plan that we're going to impose, we need to go through these formal processes and formal rulemaking and blah, blah, blah. But what if everyone just agrees? Then we don't have to do rulemaking because everyone will just agree and it'll be fine and we'll all be happy. But of course, no, not so much. The problem, of course, is that voluntary agreements need to be voluntary. Unlike the management plans, where we're going to impose it on it from on high, which we can't do because we can't agree, the voluntary agreements cannot be imposed without the operators agreeing. What's more, to substitute for the management plan, the voluntary agreement, and this is where the fun part comes in, must be unanimous. They all have to agree. All operators must sign on to the agreement. A single holdout can force the agencies back to the drawing board. So this has been the tragedy of the commons, air meets park style, because every operator has an incentive to hold out for a better deal. So they can't get everyone on the same page because everyone is like, well, if I withhold my agreement, I can get much better deal. And of course, no one is getting any deal of any kind because everyone is holding out for a better deal that will never come. You can look under the horizon all you want, but it's never coming. But no one can put down their stake. It's a Mexican standoff in the park fighting the air service. Just fantastic. In 2018, the Public Employees for Environmental Responsibility and the Hawaii Island Malama Pono Coalition, organizations representing national park employees, visitors, and hiking guides, filed a petition for a writ of mandamus that would compel the agencies to establish these management plans or voluntary plans within 2 years at 7 particular parks. So 20 years on, some people have gotten a little bit testy and like, okay, court, we cannot get these agencies to do anything. So we need a writ of mandamus. We need the extraordinary remedy. We want you, the court, to order the agencies to get their shit together. Can you please do that for us? Let's find out. In response to the litigation, the agency produced a schedule for bringing in compliance one park named in the petition and 6 other parks. It's a schedule. Ooh, that definitely mollifies us. However, the agencies have not offered a proposed timeline for the other parks, but they are pledging they'll begin preparatory work in additional parks on a rolling basis. I definitely feel assuaged by these promises. This is definitely providing me assurances. Our consideration of any and all mandamus action starts with the premise that an issuance for a writ of mandamus is an extraordinary remedy reserved only for the most transparent violations of a clear duty to act. And this is such a rare case in which a mandamus relief is appropriate. For 19 years, the agencies have failed to comply with the statutory mandate despite Congress's command to make every effort to do so within 2 years. Why can't you play nice to each other? You have pretty different jurisdictions. It shouldn't be that hard. And the agency's latest proposed schedule is too little, too late. At some point, promises are not enough. Judicial intervention is needed. So, yeah, we can't get a writ of mandamus related to the Flynn case, but we can definitely get a writ of mandamus ordering the National Park Service and the FAA to play nice and create some air management plans so people can view national parks from the air. How pleasant. In evaluating a petition for this writ of mandamus relief based on an unreasonable agency delay, we consider the following 6 factors. The time agencies take to make decisions must be governed by a rule of reason. We know we're in trouble right away. Where Congress has provided a timetable or other indication of the speed with which it expects the agency to proceed in an enabling statute, that statutory scheme must supplement content for the rule of reason. Delays that might be reasonable in the sphere of economic regulation are less tolerable when human health and welfare are at stake. The court should consider the effect of expediting delayed agency action on the agency activities of a higher or competing priority. The court should also take into account the nature and extent of the interest prejudiced by delay, and the court need not find any impropriety lurking behind agency's lassitude in order to hold the agency is unreasonably delayed. The agencies argue that the Act's timeline is aspirational. They were just hoping that we could do it within 2 years. But even a lack of a hard deadline does not give government officials carte blanche to ignore the legal obligations to play nice. Although the Act does not impose a rigid schedule, it provides a ruler against which the agency's progress must be measured. And 20 years is a bit more than 2. So, no. The agency's competing obligations cannot justify the 19-year holdup. You got to wonder what the competing obligations are again. Because lest I remind you, the National Park Service deals with the ground, and the FAA deals with the air. These feel like two very different things. Does it deal with air safety? Does it deal with air regulation? Then maybe the FAA. Does it deal with the environment and noise levels and things like that? Maybe the National Park Service. But why is it this complicated? You should be able to figure this out. Man. Neither a lack of sufficient funds nor an administrative complexity, justify extensive delay. Although we appreciate it may be difficult for agencies to complete management plans or voluntary agreements at all of the outstanding parks in the 2 years petitioners request, that does not make our mandamus relief inappropriate. Recognizing the agencies have legitimate resource-based concerns, we order the agencies to propose a schedule for bringing all the parks into compliance. In crafting the schedule, the agencies should bear in mind that Congress expected them to complete the task in 2 years ago, which, was 18 years in the past. Fun. Left to their own devices, the agencies have failed to comply with the statutory mandate for the past 19 years. Accordingly, we grant the writ of mandamus and order the agencies to produce a schedule within 120 days of the issuance of this opinion for bringing all 23 parks into compliance. Yay, get working. We fully expect the agencies will make this effort to produce this plan that will enable them to complete the task within 2 years as Congress has directed. If the agencies anticipate that it will take them more than 2 years, they must provide specific, concrete reasons for why that will do so. And then the court gives this sentence, which it will probably regret writing later. The court retains jurisdiction to approve the plan and monitor the agency response. The court has said, we're keeping this case open so I can make sure that you guys are behaving, which means the court will have to deal with this forever and ever and ever and ever. After the plan is approved, the agencies are directed to submit updates on their progress every 90 days until their obligations are fulfilled. I feel that the court is definitely going to regret writing that in the very near future. So that brings us to the end of the case of In Re, Public Employees for Environmental Responsibility, and Hawaii Coalition Malamopono petitioners, wherein the National Park Service and FAA apparently are having trouble working together because, I don't know, their jurisdiction is so overlapping, they can't figure out who would do what. They can't figure out who should do what when it comes to air travel over national parks. I don't know, maybe the FAA should deal with the air safety issues, and maybe the National Park Service should deal with the environmental impact and tourist impact issues. Maybe that's a good idea. I don't know. I'm not sure why it took me 10 seconds to figure it out, and the FAA and National Park Service haven't been able to figure it out, but they both want to be the big stick in the room, and I don't know, they're not one to play nice with each other. And the court has written a sentence it will regret. The court has written a sentence it regrets. We retain jurisdiction over this to make sure you're playing nice. Okay, let me know how that works out, I guess. At least for the moment, that's the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. If you liked this latest video, please give it a like below and hit the join button. For 99 cents a month, you too can give a recurring membership that helps this channel grow and helps YouTube to recommend this channel to others. We really appreciate your continued financial support and all your love. And until later, my friends, cheers and goodbye.